Hey everyone, I hope you're doing well and staying safe during this time. If you're new here, welcome to the channel. Like I said, thank you so much for checking me out. If you haven't done so, please make sure to hit that subscribe button just right below the video. Cool, thank you so much. I really do appreciate it. And if you're returning, welcome back. Thanks again for your support. I truly do appreciate having you here.
The SEC has filed their opposition to Garlinghouse's motion to compel these notes being turned over by Matthew Easterbrook. So if you remember, we'll step back a little bit here in time. So this was about 2 weeks ago. It's this video right here, which I'll link below, where I talked about this happening, where Brad Garlinghouse was wanting these notes released during this meeting that he had with Elid Roisman. And back then, they wanted a 1 week turnaround. The SEC asked for a timeline extension. We talked about how that would be another week delay. Instead of being filed by the 17th, it would be today, the 24th. They did get that extension, and so here we are on the 24th. And we have the document. So I apologize, I had forgotten that this was today. I was thinking tomorrow was our next big headline day, but here it is. We'll take a close look here at what they have to say and why, as you would expect, they don't want these items to get in front of Ripple. Now, it says it's 10 pages here. It's largely driven by the two exhibits, which are just statements. And we'll look at those as well, but they're pretty short. It's just the title pages that really take up space here. So again, SEC to Judge Netburn. Dear Judge Netburn, the SEC respectfully submits its opposition to the motion for a local Rule 37.2 conference by Brad Garlinghouse, alleging the SEC's assertion of the DPP over handwritten notes taken by attorney Matthew Easterbrook, counsel to then SEC Commissioner Elid Roisman, of a 2018 meeting between the Commissioner and Garlinghouse. Pursuant to the court's February 11th order, the SEC hereby submits the notes for in-camera review. The notes are no different from SEC notes this court has already held are protected by the DPP. Do remember, in that ruling from Judge Netburn, each side got something. The SEC got their extra week. Ripple, though, did get to have those documents submitted to the judge for her review versus just a blanket answer without them being assessed. So now they are submitting those to her, as well as filing this note to go along with it. Continuing on their writing here, just weeks after the court issued its January 13th order rejecting all but two aspects of defendants' broad challenge to the SEC's privilege assertions, Garlinghouse filed his motion challenging another of the SEC's privilege assertions. In the order, the court found that the DPP protected notes taken by Richard Gabbert, counsel to Commissioner Hester Peirce, at a meeting with a Ripple shareholder to memorialize information Mr. Gabbert deemed relevant to future commission decisions. The court held that the presence of Ripple's shareholder at the meeting meant the defendant's need for the notes is significantly reduced. Similarly, as to the notes now at issue, Mr. Easterbrook, counsel to Commissioner Roisman, attended the meeting with Garlinghouse and memorialized those aspects of the meeting that Mr. Easterbrook believed could relate to future commission decisions. Accordingly, the notes are pre-decisional and deliberative, and piercing the SEC's privilege is unwarranted because Garlinghouse's need for the notes is significantly reduced given his presence at the meeting, and as such the notes are protected by the DPP. Now, if you remember when we saw the response back to the SEC, they argued, the Ripple side here, Garlinghouse, his attorney, said that, hey, just because Garlinghouse was there doesn't mean that we don't need this. This further would support his testimony about this particular meeting and give further clarity too, because Brad Garlinghouse is talking just from his recollection of a meeting that happened over 3 years ago versus the actual written notes from the meeting could provide further context and, again, an outside view, not just Garlinghouse's memory and his opinion too, if the SEC wants to call his statements into question. Now here's point 1. The notes reflected matters Mr. Easterbrook believed were important and could relate to future commission decisions. As Mr. Easterbrook explains in his accompanying declaration, which is the first exhibit here, in October 2018, he had a phone call with Andrew Serezny, counsel to Ripple then and now, about setting up a meeting with Garlinghouse and Roisman. Mr. Serezny assured Mr. Easterbrook that the meeting would not relate to the open investigation of Ripple by the SEC's Division of Enforcement. The meeting requested by Mr. Serezny ultimately took place on November 9th, 2018. Mr. Easterbrook did not write down everything that was said at the meeting. Instead, he took notes of certain statements made at the meeting on matters that he believed were important and could relate to future commission decisions, including potential rulemaking regarding the regulation of digital asset offerings. The information Mr. Easterbrook chose to memorialize was intended to allow him to provide advice to Commissioner Roisman on any future rulemaking proposal. Mr. Easterbrook discovered the notes in January 2022 as he was preparing his files for his departure from the SEC. So, as we noted previously, he's on his way out and discovered these notes among his things that he felt should be included here. And if we skip down real quick to the exhibit, you can see this is just his statement saying who he is, what his job was, talking about that phone call that we just said, talking about the meeting timing and what he took notes on, and then also just stating his final day at the SEC and how he discovered the notes when he was preparing to leave. He says, though I had previously searched my files for any such notes, I did not locate them until January 2022, at which time I promptly contacted staff at the Division of Enforcement. And you can see this was signed off by him just today, February 24th. So I think part of the reason we're seeing this post just now is because they were waiting to have that statement signed by him so that they could have it here attached in the appendix. Now moving on to point 2 from the SEC, the notes are protected as deliberative process privilege pursuant to the court's order protecting notes of meetings involving Ripple and its associates. The court has already ruled the DPP protects 2 sets of relevant notes. 1, notes of a 2018 meeting that Garlinghouse and Serezny had with staff from Enforcement and the Division of Corporation Finance in connection with Enforcement's investigation of Ripple, the Ripple meeting notes, and 2, notes of a 2019 meeting between Ripple shareholder SBI Holdings and Commissioner Peirce, the SBI meeting notes. Garlinghouse notes that the notes are distinguishable from the Ripple meeting notes, but is entirely silent on the SBI meeting notes. Pointing to the Ripple meeting notes, he claims that the order set an exception for notes of meetings between Commission staff and Ripple and its lawyers that were arguably related to, or at least conceivably could have borne on the SEC's investigation of Ripple. But that is not what the court ruled. The court held that while these two sets of notes are similar in kind to the other notes taken during non-agency meetings, because Ripple or its shareholder with whom Ripple has a close business relationship was present, the need for the documents is significantly reduced. The court concluded that because these notes could reveal to defendants the SEC's internal thought processes during the meetings with Ripple and SBI Holdings to avoid the risk of revealing any such deliberations, I find that the privilege applies. That's from the court order. Nowhere did the court suggest that its ruling was premised on discussion at the meetings of enforcement's investigation of Ripple. To the contrary, the court's ruling was expressly based on the question of whether the DPP should yield to the need for discovery, which the court found depends in part on the availability of other evidence. Because Ripple or its shareholder were present at the two meetings in question, the court ruled that other evidence of the meetings was available to defendants, and therefore that the SEC's privilege should not yield to defendants' claimed need for discovery of the meeting notes. The court's reasoning applies equally here. Indeed, not only was Garlinghouse present at the meeting with Commissioner Roisman, but Garlinghouse's motion actually cites two other evidence of the meeting, including his own deposition testimony and contemporaneous records of the meeting that have already been produced. Moreover, even accepting Garlinghouse's incorrect argument that the court's ruling as to the Ripple meeting notes was somehow related to discussion of the SEC staff's investigation of Ripple, no such suggestion can extend to the SBI meeting notes. Garlinghouse argues that because Mr. Easterbrook and Commissioner Roisman were not involved in the investigation, there is no danger of the meeting notes revealing the SEC's thought processes about the investigation. But the same was true of Commissioner Peirce and her counsel with respect to the SBI meeting notes. They too were not involved in enforcement investigation, and therefore the SBI meeting notes would not reveal her thought processes about the investigation. The SEC has not argued otherwise, and the court did not suggest otherwise. Now I'm going to pause here real quick. I think that what the SEC is doing here is tying this very closely to one that the judge has already ruled on. I think that's actually a good approach on their part, because they found a similar item where she said this is privileged, and now they're trying to just say this is the same type as that. And so because you ruled this way on that document, this is materially similar, so it should be likewise. That's the argument they're making here. That's what they're contending. But I want to know in the comments below if you think that that sort of argument holds water, or if each document or set of documents should stand on their own merits. Let's continue. Indeed, Garlinghouse cannot make a credible distinction between the two sets of notes, and has not even attempted to do so. To the contrary, the notes Mr. Easterbrook took of Commissioner Roisman's meeting with Garlinghouse are no different than the notes Mr. Gabbert took of Commissioner Peirce's meeting with SBI. Both sets of notes reflect information that counsel for an SEC commissioner deemed relevant to formulating a position as to a future commission decision. Commissioner Peirce's counsel memorialized information he deemed relevant to formulating a position as to whether offers and sales of XRP constitute offers and sales of securities. That position was relevant to Commissioner Peirce's vote on any later enforcement recommendation to file a lawsuit against Ripple. Similarly, Commissioner Roisman's counsel memorialized information relevant to a potential future rulemaking proposal regarding the regulation of digital asset offerings. Just as the court held that the SBI meeting notes could reveal the SEC's internal thought processes during the meeting with SBI, so too could disclosure of the notes reveal Mr. Easterbrook's thought processes during the meeting with Ripple. As Mr. Easterbrook states in his declaration, he took the notes to gather information that would allow him to provide advice to Commissioner Roisman on a potential future proposal by the Commission of a rule regarding the regulation of digital asset offerings. Mr. Easterbrook was selective in what he chose to memorialize and wrote down information on the matters discussed at the meeting that he believed were important and that could relate to future commission decisions. The notes thus reflect Mr. Easterbrook's exercise of judgment and were prepared to help a member of the SEC formulate his position on a future commission decision. The notes are therefore pre-decisional and deliberative, and then they note here, citing that EPA case, DPP protects EPA officials' notes from an internal meeting because notes reflected officials' priorities and interest in particular topics or statements made during the meeting. Now, continuing, moreover, piercing the SEC's privilege is not warranted. Factors relevant to piercing DPP include 1. Relevance of the evidence sought to be protected. 2. The availability of other evidence. 3. The seriousness of the litigation and the issues involved. 4. The role of the government in the litigation. And 5. The possibility of future timidity by government employees who will be forced to recognize that their secrets are violable, and those are the factors that they cite over and over, and the judge as well, when determining whether to pierce the DPP. Those 5 items, this 5-item test we've seen in multiple sets of documents so far when there's been a DPP discussion. These factors weigh heavily against the disclosure of the notes. First, the court has already ruled that the need for privileged meeting notes is significantly reduced where other evidence can be obtained from representatives or associates of defendants who were present at the meetings. There can be no question that information reflected in the notes is available from other sources that Garlinghouse expressly cites in the motion, including his own testimony and contemporaneous records of the meeting. That's the emails they're referring to, the back and forth at Ripple. Garlinghouse ignores the court's prior ruling and argues instead that the information in the notes is available from no other source because he is the defendant in the case. But the court has already found that Garlinghouse's presence on Ripple's behalf at the 2018 meeting with the SEC staff means that Garlinghouse is a source of, quote, other evidence, notwithstanding that he and Ripple are also defendants in the case. Second, Garlinghouse's sole argument as to why the notes are relevant is based on the Scienter-based claim against him, which is the subject of an outstanding motion to dismiss, since it is not yet clear if the Scienter-based claim against Garlinghouse will proceed, and if it does, Garlinghouse will be able to take discovery on that claim. The court should not pierce the DPP at this time because of the purported relevance of the notes. So you can see they're acknowledging that even still the notes could be applicable if the case against Garlinghouse goes forward. They just don't want it revealed yet. They want to buy themselves some more time. Third, disclosure of deliberative notes taken by counsel to an SEC commissioner to assist in advising the commissioner on agency decisions could chill future deliberations of other agency employees as they make judgments about which matters to memorialize and which to forgo memorializing out of fear that their thought processes may be subject to disclosure. Garlinghouse argues that meetings between commissioners and market participants are not freewheeling, informal internal discussions where a shield is necessary to promote candor in policymaking. But he ignores the central issue that Mr. Easterbrook and other SEC employees should feel free to record information on matters that they deem important to agency decision making. Whether they are meeting internally or with external parties, SEC staff's internal thoughts should not be subject to disclosure. And this is especially so, whereas here, the need to promote candor to improve agency decision making is critical, given the importance in having the SEC get it right on the highly consequential decisions of how or whether to regulate digital assets. Finally, they've gotten here to the end. 4 pages to say a lot of the same thing. But finally, the court should reject Garlinghouse's attempt to equate the notes with a memorandum to file that the SEC has introduced in this litigation relating to a 2018 meeting among then SEC Chair Clayton, Garlinghouse, and Ripple CTO David Schwartz. That memorandum, which Garlinghouse appends to his motion as Exhibit G, was prepared by Chair Clayton's Deputy Chief of Staff and Senior Policy Advisor, both of whom signed the document. As is clear from its face, the memorandum was prepared to memorialize an improper attempt by Garlinghouse to discuss enforcement's open investigation of Ripple with Chair Clayton. So they're calling out Garlinghouse for asking a question from the SEC when he was present with the SEC, which agency has told members of the financial community to come in and talk to them. So they are lambasting Garlinghouse for doing exactly what they've been told to do by the SEC. That's pretty shocking here. But we'll continue here. The memorandum states that in response, Chair Clayton immediately stated that the meeting was not the proper forum for a discussion about that topic and asked Garlinghouse to back up from that issue. The memorandum, which is just 2 paragraphs long, also notes that the meeting lasted approximately 15 minutes and that Garlinghouse and Schwartz spent the meeting discussing Ripple's business and technology, and that representatives from the chairman's office occasionally interjected with questions, but does not provide any additional details about those discussions. This memorandum contains no deliberations by SEC staff and is thus not subject to the DPP, and the memorandum has no relevance to multiple pages of contemporaneous notes taken by Mr. Easterbrook in order to assist him in advising Commissioner Roisman on future agency decisions. For the foregoing reasons, the SEC respectfully submits that the notes are protected by the DPP and that the court should not order their disclosure. Respectfully submitted, Leighton Stewart. Again, we see her a lot on these documents. And then also just here at the very end, you can see there's a declaration by Vanessa Countryman, who is secretary at the SEC, and this has to do with the things that we've seen up to this point, the DPP being asserted on Easterbrook's statements, or notes rather. So there you have it. The SEC continuing to try and keep documents privileged. These notes from the meeting between Roisman and Garlinghouse could contain useful information for Garlinghouse's case, but the SEC certainly does not want them to be made public. However, Judge Netburn has decided that she will at least review them. So now the ball is in her court as to whether or not these will see the light of day, and we have the opportunity to discuss them at a future point. So let's hope that she makes a decision to allow.
I'm your guy. I will keep you posted. I'm your advocate. I'll be back on a daily basis, usually multiple times per day, with these videos to keep you updated with everything going on. So I hope you enjoyed the video. If you haven't done so, make sure to hit that subscribe button. Feel free to share any of my videos with your friends, family, social media, or anybody who may care to listen. Thanks so much for your continued support. I'm always here for you. I want to help you through this time. So thank you so much for continuing to choose me. Enjoy your day, stay safe, and I'll catch you again probably in a couple hours. Thanks, everybody. See you later.